Welcome to
Ducky Channel.
Welcome to the brief of the Defendant Appellant Steven A. Avery in the final part, 7. Part 7. Mr. Avery raised sufficient reason as to why these issues could not have been raised in prior motion pursuant to Wisconsin State 974.06. In its October 3, 2017 order, the Circuit Court found that Mr. Avery failed to overcome the procedural bar to having his motion heard. In so ruling, the Circuit Court held, quote, "There is no argument or showing of a sufficient reason as to why these issues could not have been raised in prior motions. Without such sufficient reason, these arguments are precluded from any subsequent motion." State v. Escalona, Navarra. Part A, Standard of Review. Whether Mr. Avery's claims are procedurally barred depends upon the proper interpretation of Wisconsin Statute 974.06, which is a question of law that this court must review de novo. Part B. Mr. Avery has demonstrated a sufficient reason for failing to raise the current claims earlier. The Wisconsin Supreme Court has articulated two requirements for bringing a successive ineffective assistance of counsel claim in compliance with 974.06, State v. Romano, Georgiana. First, the defendant must show a sufficient reason for failing to raise the current claims earlier. Second, the defendant must demonstrate that the claims made now are clearly stronger than previous claims. The Circuit Court overlooked current post-conviction counsel's argument in Mr. Avery's motion for post-conviction relief filed on June 7, 2017, that the ineffectiveness of prior post-conviction counsel is a sufficient reason and of itself. Prior post-conviction counsel failed to hire experts, conduct a significant investigation, or review discovery in order to impeach Bobby with Brian's statements. Shortly after the Wisconsin Supreme Court decided Escalona, the Court of Appeals held that ineffective assistance of post-conviction counsel may constitute sufficient reason for not raising issues in a previous post-conviction motion. Rothering, State v. Aaron, the Wisconsin Supreme Court has gone so far as to note that, following Rothering, ineffective assistance of counsel claims are not barred by Escalona Noyara. The Court of Appeals has concluded that an ineffective assistance of counsel claim is not barred by State v. Escalona Noyara. Citation omitted. In Balliete, the Wisconsin Supreme Court again reaffirmed the principle set forth in Rothering. Ineffective assistance of post-conviction counsel may be sufficient reason why claims were not raised before. Balliete. In its analysis, the Balliete Court accepted the defendant's sufficient reason post-conviction counsel was ineffective and analyzed the merits of his ineffective assistance of counsel claims. Thus, when a defendant alleges ineffective assistance of post-conviction counsel as a sufficient reason under Escalona and 974.06, the court should accept the preferred offer as sufficient and analyze the merits of whether post-conviction counsel's performance was, in fact, constitutionally deficient. Here, the Circuit Court erred when it neglected to analyze Mr. Avery's claim of ineffective assistance of prior post-conviction counsel on the merits. Because Mr. Avery alleged ineffective assistance of prior post-conviction counsel as a sufficient reason, the Circuit Court should have weighed Mr. Avery's claims to determine if prior post-conviction counsel rendered ineffective assistance. The Circuit Court could only find Mr. Avery was procedurally barred from raising the instant claims if prior post-conviction counsel was not ineffective. Because the trial court neglected to weigh the merits of Mr. Avery's sufficient reason, Mr. Avery is entitled to relief. Part C. Mr. Avery's pre-C motion. Whether Mr. Avery claims are procedurally barred depends upon the proper interpretation of Wisconsin Statute 974.06, which is a question of law that this court must review de novo. The Circuit Court failed to acknowledge the sufficient reason raised Mr. Avery's pleading. Mr. Avery claimed in his pro se petition that the trial judge was biased. The preliminary hearing judge should have recused himself from the trial. The search warrants were defective because lacked seal or signature, cited wrong statute. Trial counsel was ineffective regarding chain of custody for the RAV4, and for stipulating that he was a convicted felon, and for not having a qualified scientific expert. The trial court was incompetent to hear an appointed special prosecutor. In its October 3, 2017 ruling, the trial court reasoned that Mr. Avery's prior pro se motion filed under 974.06 recognizes significant legal issues with the court has previously ruled on. The reasoning led the court to conclude that the claims raised in Mr. Avery's recent 974.06 motion were barred because Mr. Avery could have raised them earlier. The circuit court failed to acknowledge the significant reasons raised in the pleading of current post-conviction counsel, but unambiguously ruled that all claims Mr. Avery raised in his pro se motion lacked merit in its order dismissing the motion. The circuit court found that in Mr. Avery's pro se motion, quote, most of the authority cited by Mr. Avery, quote, had little or nothing to do with the position he sought to advance. Further, the circuit court noted that Mr. Avery, quote, provided no factual information of any evidentiary value that supported his claims. The circuit court went on to conclude that every claim raised by Mr. Avery was, quote, unsubstantiated, quote, empty and without substance, quote, completely meritless, quote, bordering on frivolous, quote, wildly speculative, and, quote, contrary to Wisconsin's long-standing law and procedures. Mr. Avery made extensive use of federal case law, citing and quoting from a number of federal courts of appeals and U.S. Supreme Court cases, most of which were non-germane to the claims he sought to advance. Ultimately, the circuit court found that the allegations made by Mr. Avery did not warrant relief. Contrary to the circuit court's October 3, 2017 opinion, current post-conviction counsel's motion alleged sufficient reasons why the current claims were not raised in the pro se motion. In his second motion for post-conviction relief, Mr. Avery submitted his lack of knowledge of factual and legal basis, cognitive deficiency, indigenous incarceration, collectively as a sufficient reason for not raising the claims in his pro se motions. Quote, a defendant's unawareness of the factual and or legal basis for his claims may constitute a sufficient reason for his failure to raise those claims. Noting a defendant's unawareness of legal basis of his claim may constitute a sufficient reason in satisfaction of 974.06 State v. Howard. The circuit court did not analyze whether these collective circumstances constituted a sufficient reason, and Allen, the Wisconsin Supreme Court, noting the procedural hurdles imposed by Escalon and Navarro, stated that a defendant could raise an issue which for sufficient reason was not raised or was inadequately raised in a prior motion. The Wisconsin Supreme Court then went on to entertain Allen's argument that he had sufficient reason for raising his current claim because he was unaware of his claims at the time. Mr. Avery wrote to dozens of attorneys, all of whom rejected his request for representation following the denial of his direct appeal. Mr. Avery also wrote to laboratories that would not respond unless he had an attorney. Mr. Avery, who is learning disabled, simply lacks the legal acumen and financial resources necessary to advance an even arguable meritorious claim in a post-conviction motion, let alone the claims raised based on countless hours of investigation and consultation with experts. As a result, Mr. Avery has sufficient reason for not including his current claim based on trial counsel's failure to hire experts and to investigate and present evidence about the alternative suspect in his original post-conviction motion. Part 8. The Circuit Court abused its discretion in denying Mr. Avery's motion to reconsider and his 3 supplement to said motion, which included new evidence developed after his original filing on June 7, 2017. Part A. Standard of Review. This court reviews the Circuit Court's ruling on a motion for reconsideration under the erroneous exercise of discretion standards. Cope sells old popcorn wagons. An appellate court reviews the circuit court's factual findings regarding what occurred under the clearly erroneous standard, but will independently consider whether those facts fulfill the legal standard. Part B. Mr. Avery's motion for reconsideration and its supplementals presented new evidence not ruled upon in the court's October 3, 2017 order. On October 23, 2017, Mr. Avery filed a motion for reconsideration based on manifest errors of law and the development of new evidence. Mr. Avery subsequently supplemented and amended the motion to reflect the discovery of additional evidence. On November 28, 2017, the Circuit Court entered an order denying Mr. Avery's motion to reconsider. Mr. Avery's motion for reconsideration were properly filed. Wisconsin Statute 805.17 permits a party in an action tried to the court to move for reconsideration of the court's findings, conclusions of law, and judgment upon motion of a party made not later than 20 days after entry of judgment. Although Wisconsin Statute 80517 is a rule governing civil actions, rules of practice in civil actions apply in all criminal proceedings, quote, unless the content of the rule manifestly requires a different conclusion. State v. Haynes. Wisconsin Statute 974.06 vests a circuit court with the attorney to entertain a motion alleging that a prisoner's sentence has been imposed in violation of Constitution, grant a hearing, determine the issues, and make findings of fact and conclusions of law. Moreover, proceedings under Wisconsin Statute 974.06 shall be considered civil in nature. Therefore, the civil rule allowing a party to file a motion to reconsider a court's judgment applies to the Circuit Court's denial of the motion for post-conviction relief pursuant to Wisconsin Statute 974.06. Furthermore, the common law vests a court with the inherent authority to correct an error by reconsideration. Motions for reconsideration are common in Wisconsin trial courts and have become part of our common law. See also State v. Brockett. Holding that trial court properly ruled on state's motion to reconsider trial court's order granting post-conviction relief. Thus, even if the circuit court did not have the authority to rule on Mr. Avery's motion to reconsider pursuant to Wisconsin State 80517, it did have the discretion to consider his motion under the common law. An order denying a motion for reconsideration is not applicable unless the motion raised issues that were not resolved by the order sought to be reconsidered. State v. Edwards. In other words, an order is not applicable where the only issue raised by the motion were disposed of by the original judgment or order. The new issues test for determining whether an order denying reconsideration is applicable is to be applied liberally. Here, Mr. Avery's motion for reconsideration raised, quote, new issues that were not disposed of by the circuit court in its original order denying him relief. Quote, to prevail on a motion for reconsideration, the movement must present either newly discovered evidence or establish a manifest error of law or fact. New evidence presented in the motion for reconsideration and its supplements. Mr. Avery's motion for reconsideration and its supplements raised the following new evidence. Number 1, affidavits from trial defense counsel admitting ineffectiveness in hiring blood and ballistic experts. Number 2, affidavit from trial defense counsel's investigator, Mr. Bias, that they were ineffective in impeaching Bobby with the testimony of Brian that he had told the police Bobby witnessed Miss Halbach leaving the Avery property on October 31, 2005, contrary to Bobby's trial testimony. Brady violations including the following. A. Mr. Romlow's affidavit that he saw the RAV4 away from the Avery property on November 3rd and reported it to Sergeant Colburn, who never disclosed a report to the trial defense counsel. B. Heidel-Coakley report, which was not turned over to trial defense counsel. C. Experiment conducted demonstrating that Bobby was at the same location as Halbach when she received her last call at 2:41 p.m. 4. New forensic examination by Mr. Hunt of the 7 DVDs from the Dassey computer. A. Reveals images of Mrs. Halbach and Mr. Avery. B. Reveals violent pornographic images on Dassey computer. C. Mr. Hunt determined that the internet was accessed on October 31st, 2005, when only Bobby was at home at 6:05 a.m., 6:28 a.m., 6:31 a.m., 7 o'clock a.m., 9:33 a.m., 10:09 a.m., 1:08 p.m., and 1:51 p.m. This impeaches Bobby's trial testimony that he was asleep from 6:30 a.m. to 2:30 p.m. D. New computer forensic examination reveals deletions on the Dassey Yonda computer. E. Brad Dassey's affidavit that Barb hired someone to reformat the Dassey Yonda computer shortly before it was seized by authorities. She wanted to know if reformatting, quote, would remove what was on the computer. Number 5. New recorded telephone conversation on October 24, 2017, between Mr. Avery and Barb and Scott Tadich, in which they admitted that they knew Miss Halbach left the Avery property on 10/30/17. Number 6. Barbara's Facebook statement on October 30, 2017, that Bobby had admitted to her that he did not see Miss Halbach walking toward Steven's trailer, as he testified to at trial. Number 7. Blaine has provided an affidavit to current post-conviction counsel admitting that he lied at trial about the fire in Mr. Avery's sperm barrel. None of these issues were addressed by the Circuit Court in its original order to dismiss Mr. Avery's motion, nor could they, given that all of them were based on the discovery of new evidence that was either withheld from Mr. Avery or, through no fault of his own, was not in Mr. Avery's possession at the time he filed his prior post-conviction motions. Part 9. The Circuit Court abused its discretion in ignoring the subsequent brief submitted by the parties incident to the motion to supplement. On June 7, 2018, the Appellate Court ordered that, quote, this appeal is remanded forthwith to the Circuit Court to permit Steven A. Avery to pursue a supplemental post-conviction motion in connection with Avery's receipt of previously withheld discovery or other new information, emphasis added. The Circuit Court ignored this court's specific order to allow the inclusion of new information in the motion to supplement. On November 6, 2018, the Circuit Court ruled. Nowhere in the very specific orders of the Court of Appeals did the court allow for a reply brief by the state or a response by the defendant, because the Court of Appeals was so detailed in its instructions. The court did not consider the subsequent brief submitted by the parties after the defendant's court-ordered filing. The court followed the order of the Court of Appeals and only considered the initial brief of the defendant. Mr. Avery filed a motion to compel for production of the examination of the Dassey Yonda computer that was performed over an 8-month time period. The Circuit Court never ruled on Mr. Avery's motion to compel. Current post-conviction counsel obtained an affidavit from Barb on August 2, 2018, wherein she described Investigator Dietering telling her, quote, you should not give the computer to Kathleen Zellner. The Circuit Court never ruled on current post-conviction counsel's motion to compel or whether the computer would be tendered to current post-conviction counsel. Barb voluntarily turned the computer over to current post-conviction counsel, and after careful forensic examination of the computer data, Mr. Hunt concluded there were, quote, massive image deletions that would render any new forensic examination meaningless. Current post-conviction counsel's computer forensic expert was unable to determine when the massive deletions occurred, leaving open the possibility that law enforcement was responsible for the deletions. Because the Circuit Court denied a hearing, the issue of the deletions remains unresolved. Part 10. The Circuit Court erred in denying Mr. Avery's supplemental motion for post-conviction relief pursuant to Wisconsin Statute 974.06 concerning the discovery of human bones in the Manitowoc County gravel pit before trial. It is well settled that this court reviews the denial of Wisconsin Statute 974.06 motion using a mixed standard of review. First, we determine whether the motion on its face alleges sufficient material facts that, if true, would entitle the defendant to relief. This is a question of law that we review de novo. If the motion raises such facts, the Circuit Court must hold an evidentiary hearing. We review a Circuit Court's discretionary decisions under the differential erroneous exercise of discretion standards. State v. Allen, citations omitted. On February 25, 2019, the Appellate Court granted Post-Conviction Counsel's motion to supplement the record on appeal with an undisclosed police report and allowed current Post-Conviction Counsel to file a supplemental post-conviction motion. The Appellate Court further remanded the appeal to the Circuit Court to, quote, conduct any proceedings necessary to address the claims raised in the supplemental post-conviction motion and to enter an order containing its findings and conclusions. On August 9, 2019, the Circuit Court entered an order without conducting any further proceedings denying Mr. Avery's supplemental 974.06 motion. Mr. Avery's motion alleged claims for relief in connection with the state's violation of Wisconsin State 968.205, the evidence preservation statute, and the violation of his due process right to the preservation of evidence as protected by Youngblood v. Arizona. First, Mr. Avery's 974.06 motion alleged sufficient material facts that, if true, would entitle Mr. Avery to relief. This court reviews Mr. Avery's claims of error de novo, Allen 2004. Mr. Avery is entitled to an evidentiary hearing on both his Wisconsin Statute 968.205 and constitutional right claims because evidence establishing that human remains were removed from a location other than Mr. Avery's property refutes the state's theory that all the human remains were recovered from a location under Mr. Avery's exclusive control. Indeed, if Ms. Halbach's remains were actually in the gravel pit, then the defense would have been able to substantiate and not just speculate about an alternative theory that someone other than Mr. Avery murdered Ms. Halbach and moved her bones to Mr. Avery's burn pit to frame him. In order to successfully convict Mr. Avery, the state presented a false forensic story to the jury, which claimed that the bones in the gravel pit were, quote, not evidence, because they were not human and therefore could not have been Mrs. Halbach. The issue on remand to the Circuit Court was whether the state violated Youngblood v. Arizona and Wisconsin Statute 968.205 when it returned the human bones to the Halbach family in 2011 without giving any notice to Mr. Avery or his counsel. Mr. Avery's supplemental 974.06 motion alleged material facts sufficient to establish a violation of the Wisconsin Evidence Preservation Statute, Wisconsin Statute 968.205, and Youngblood. Because 968.205 does not provide a remedy for convicted persons in the event of a violation, fashioning a remedy is left to the courts, an action Wisconsin courts have yet to take. Mr. Avery's supplement 968.205 motion contained sufficient material facts for the Circuit Court to fashion a remedy for such evidence preservation violations, controlled by United States Supreme Court precedent addressing evidence preservation violations. See California v. Trombetti. Taken together, Trombetti and Youngblood comprise a line of constitutional jurisprudence that outlines the extent of the state's duty to preserve evidence. Youngblood. The Trombetti test focuses on the probative value of the destroyed evidence and whether the evidence possessed exculpatory value that was apparent before the destruction. The Youngblood test examines the government's role in the circumstances that led to the destruction of the evidence. If a criminal defendant can satisfy either test, then a court will rule the destruction of the evidence was a violation of due process and reverse the defendant's conviction. Youngblood 488 U.S. The Due Process Clause of the 14th Amendment to the United States Constitution imposes a duty on the state to preserve exculpatory evidence. State v. Greenwald. The state failure to preserve evidence violates a defendant's due process rights if police 1. Failed to preserve evidence that is apparently exculpatory, or 2. Acted in bad faith by failing to preserve evidence that is potentially exculpatory. State v. Greenwald. The Circuit Court mistakenly found that the evidence destroyed by the state through the CCSD and prosecutors Gahn and Fallon was not material because it was not human. The Circuit Court's finding reveals that failure of the court to acknowledge and understand the Eisenberg reports provided to the court by Mr. Avery. Part A. Materiality. The Applicability of either Trombetti or Youngblood depends upon the materiality of the evidence that was lost or destroyed. A hurdle to applying these tests is the difficulty of definitively knowing the material value of evidence that no longer exists. However, in the context of addressing the materiality of evidence lost or destroyed in violation of Wisconsin Statute 968.205, the Wisconsin legislature has already resolved that problem, especially when considered together with 974.07, the DNA Evidence Preservation Statute demonstrates the Wisconsin legislative recognition of the importance of post-conviction DNA testing. These statutes taken together provide for the preservation of biological evidence and, in many instances, subsequent DNA analysis. The codified right to DNA preservation and testing shows the legislative intent to ensure that DNA testing of biological evidence plays, quote, a significant role in the suspect's defense and efforts to obtain post-conviction relief. Trombetti 467 U.S. Therefore, the Wisconsin legislature, through the DNA preservation statute, has placed preserved biological evidence in the class of evidence the United States Supreme Court deemed material, as defined in Trombetta and Youngblood. Part B. Potentially exculpatory evidence preserved under Wisconsin Statute 968.205. Second, following from this presumption of materiality, the DNA evidence preservation statutes further presume that in every case, biological evidence collected in the course of criminal investigation is at least, quote, potentially exculpatory, as defined in Greenwald 2. In the context of DNA evidence, quote, apparently exculpatory, evidence includes instances where results from testing or retesting of biological evidence that excluded the petitioner would exonerate him or her of the crime of conviction. See National Comment on the Future DNA Evidence, U.S. Department of Justice, Post-Conviction DNA Testing, Recommendations for Handling Requests for 1999. Similarly, potentially exculpatory DNA evidence refers to evidence in cases where, if subjected to DNA testing or retesting, exclusionary results would support the petitioner's claim of innocence. In line with the Supreme Court's reasoning in Youngblood, this category includes evidence that was, quote, simply an avenue of investigation that might have led in any number of directions, and evidence about which, quote, no more can be said than that it could have been subjected to tests, the results of which might have exonerated the defendant. These categorical requirements for, quote, potentially exculpatory evidence necessarily apply to biological evidence covered by the DNA evidence preservation statute. Because preserved evidence test shows allow, quote, reasonable persons to disagree as to whether the results of DNA testing rule out the possibility of guilt or raise a reasonable doubt of guilt. Youngblood 488 U.S. Therefore, evidence covered under the Biological Evidence Preservation Statute must be deemed at least, quote, potentially exculpatory, and the loss or destruction of such evidence triggers at minimum the Youngblood due process analysis. Part C. The DNA Evidence Preservation Statute presumes that every violation constitutes bad faith. The Youngblood court reasoned that law enforcement actions suggesting, quote, bad faith arise when, quote, police themselves by their conduct indicate that the evidence could form a basis for exonerating the defendant. This consideration in turn hinges, quote, on the police's knowledge of the exculpatory value of the evidence at the time it was lost or destroyed. In these cases, quote, bad faith exists when the conduct of the police is outside the scope of normal practice. The Youngblood court's definition, quote, bad faith, takes for granted that there are times when the police will not know whether evidence was material before its loss or destruction. The DNA preservation statutes eliminates this assumption by creating an affirmative duty to preserve all biological evidence taken from the crime scene. Therefore, law enforcement agencies are on notice that biological evidence is deemed important to the successful administration of criminal justice and may not claim ignorance that the destroyed evidence was at least potential exculpatory. Wisconsin Statute 968.205 imposes certain duties upon law enforcement agencies. At the most basic level, the state bears a duty to preserve all biological evidence collected during the course of an investigation that leads to a conviction. Additionally, the statute sets forth the steps the state must take before lawfully destroying such evidence in its possession. Because a violation of DNA preservation statute means the state did not abide by either the requirements for preservation or the proper destruction of the evidence as required by law, such conduct constitutes, quote, bad faith. Youngblood's potential exculpatory combined with bad faith requirement is met. Under the Youngblood test, courts would examine whether the evidence was potentially exculpatory, and if so, whether the police acted, quote, bad faith when they destroyed the evidence. In light of the presumptions created by the DNA evidence preservation statute, the trial stipulation, the pretrial FBI examination, and the April 4, 2007 order mandates that the evidence be considered potentially exculpatory. As set forth above, the presence of, quote, bad faith should be presumed every time the Wisconsin Statute 968.205 DNA evidence preservation statute is violated. Here, the failure to give notice to Mr. Avery and his attorney violated the statute and constituted bad faith, as did returning the gravel pit bones to the Halbach family, in violation of Wisconsin Statute 968.205 and the April 4, 2007 trial court order. The state cannot credibly argue that it returned animal bones to the Halbach family for burial or cremation. Based on the foregoing, Mr. Avery set forth sufficient material facts pertaining to the destruction of apparently exculpatory or potentially exculpatory human bone fragments to warrant an evidentiary hearing. Despite the circuit court's erroneous ruling to the contrary, Mr. Avery is entitled to such a hearing on his claims because the material facts he alleged in his supplemental 974.06 motion, i.e. who, what, when, where, why, and how, are sufficient to show that he is entitled to relief. Second, the circuit court erred when it found that Mr. Avery's motion did not on its face state material facts that, if true, would entitle him to relief. The court reviews the circuit court's decision to deny Mr. Avery's supplemental 974.06 motion without a hearing under the deferential erroneous exercise of discretion standard. The circuit court failed to analyze the sufficiency of the material facts he alleged in his motion. Instead, the circuit court denied Mr. Avery's claim by blatantly misstating the evidence in the record. Specifically, the circuit court erred in concluding that the Manitowoc County gravel pit bones were non-human, when in fact, the Manitowoc quarry bones were labeled as, quote, human by Dr. Eisenberg in her reports describing property tag numbers 7411, quote, calcined human bone fragments, number 7412, human and non-human bone, 5 of 13 burned, calcined, with cut edges. Most bone fragments, or all cut bone fragments, are human. Number 7413, quote, 1 burned human fragment. Number 7414, quote, burned, calcined, human bone fragment. Number 7416, quote, human bone fragments, human is calcined with 1 cut edge. And number 7419, cut, burned human bone. The circuit court appears to have ignored the key report of Dr. Eisenberg, which is clearly referenced in paragraph 14 of Mr. Avery's 968.205 Youngblood motion. As stated in paragraph 14 of Mr. Avery's motion, Dr. Eisenberg's critical report is attached to Mr. Avery's December 17, 2018 motion. Inexplicably, and although Mr. Avery supplied all of the relevant property inventory item numbers for the gravel pit bones relevant to his claim, the circuit court reviewed Dr. Eisenberg's trial testimony, which only addressed number 8675, and dismissed Mr. Avery's claims based solely on that testimony. Mr. Avery has never contended and does not contend now that number 8675 contains bones determined by Dr. Eisenberg to be human. Dr. Eisenberg testified at trial consistently with her forensic anthropology report that number 8675 contained only, quote, suspected human pelvic bones. As noted above, Mr. Avery had an agreement with the state to test number 8675 as part of the agreement reached between the parties in September 18, 2017. By completely ignoring the relevant Eisenberg report, the circuit court abused its discretion by concluding that Dr. Eisenberg was testifying about all the gravel pit bones. Dr. Eisenberg was only referring to the pelvic bone that were labeled number 8675. At no time did Dr. Eisenberg testify at trial about her other report, which identified numerous gravel pit bones as being human. All of these bones were returned to the Halbach family for burial or cremation. Because the circuit court's analysis of Mr. Avery's claim related to Dr. Eisenberg's finding was so deeply flawed, the trial court erroneously exercised its discretion. If the circuit court had granted an evidentiary hearing, the single but fatal mistake would have never occurred. Therefore, the circuit court's order denying Mr. Avery's supplemental 974.06 motion without an evidentiary hearing must be reversed. Conclusion. For the reasons stated herein, Steven Avery respectfully requests that this court grant him one of the following alternative remedies. Number 1. Reverse the orders denying post-conviction relief and remand for the state to file a response to the motion for post-conviction relief and or grant an evidentiary hearing. 2. Reverse the judgments of conviction and the orders denying post-conviction relief and remand for a new trial. Dated this 11th day of October, 2019. Respectfully submitted, Kathleen T. Zellner, Stephen G. Richards.
'Cause the days are gonna whisper and the months are gonna talk until the years shall